Our third speaker in this session is the Honorable Judge James Ross from Beaver County. Judge Ross was a federal prosecutor for many years. He was a private defense attorney for many years in Beaver County. And Jim has seen a lot of interesting DNA cases and how DNA can be used or abused. Throughout his entire career, he again is a fierce advocate for truth, and he's gotten interested in how science can help with that. So, Judge Ross.
Good afternoon, everyone. I'd really like to thank Dr. Perlin for this opportunity to be here today. I established a relationship with Dr. Perlin 5 years ago in a case that I had, and he taught me a lot about DNA. My first experience with forensic science was in 1984. I see a friend of many years in the audience, Linda Kelly, our former Attorney General. She and I worked in the United States Attorney's Office together. And at that time, I had the good fortune to come into the office with Judge Ignelzi and Chuck Sheehy and Judge Manning were my mentors. My first experience to forensic science was mainly with handwriting experts and fingerprint analysts. And I can tell you that what would essentially happen is someone from the FBI would come in on the day of their testimony. You would meet with them. They would show you the fingerprint. They would give you 2 pages of questions and say, ask me these. You respected these people so much that you just followed their lead. I remember one of the very, very first cases I tried with a fingerprint expert. I put him on the witness stand. He testified to his background and credentials. He testified that he had been the fingerprint analyst who was assigned to the plane crash in the Andes Mountains where 400 people were killed and the bodies were decimated. He identified them all. The jury was mesmerized. He gave them the testimony about the fingerprint. The man was convicted. I never really thought too much about it until recently. That happens today in virtually all prosecutors' offices. Prosecutors and defense lawyers know very little about the procedure that goes on in a laboratory. They know very little about the process that is used, the methodology. And I can venture to say today, I believe, that when state police analysts come into courtrooms, they do much of the same thing. They give their report, they give the questions. These are the questions that you should ask me. I never really thought about looking behind the report. When I was in the United States Attorney's Office, I never really thought much about the methodology. And then I realized that in 2005, Congress saw a problem with forensic science. They vested the National Academy of Sciences with the responsibility of studying forensic science. And for those of you who have not read this book recently or know about it, you should pick it up. Strengthening Forensic Science in the United States. In 2009, the National Academy wrote this report, and they talked about the problems with forensic science. Part of what fueled that, so you know, was the advent and onslaught of use of DNA in criminal prosecutions. That is addressed in here. And one of the things that they do mention is the fact that DNA is often used when it's not relevant. And they give this situation or the description of, or the contrast in which DNA is found in a house in which a husband assaults or kills his wife. Well, if it's found in the house, it's of no consequence because they live together. It's there. It should be there. If, however, in contrast to that, it's found under the victim's fingernails and it's positively identified as the husband's at that point, then it becomes much more relevant. So one of the recommendations that they talk about is the fact that you not only have to consider the DNA as proffered, but the circumstances under which it is proffered. And then this statement is made on page 100 of the book. Among existing forensic methods, only nuclear DNA analysis has been rigorously shown to have the capacity to consistency and with a high degree of certainty demonstrate a connection between an evidentiary sample and a specific individual or source. Indeed, DNA testing has been used to exonerate persons who were convicted as a result of misapplication of other forensic science evidence. However, this does not mean that DNA evidence is always unassailable in the courtroom. There may be problems in a particular case with how the DNA was collected, examined in the laboratory, or interpreted, such as when there are mixed samples, limited amounts of DNA, or biases due to the statistical interpretation of data from partial profiles. It's the very thing that these gentlemen were just talking about. I have seen that played out first as a lawyer and then as a judge. I can tell you that I have presided over 2 homicide cases, and I've learned about many other homicide cases that have been prosecuted in our court. And I can tell you that in almost every homicide case anymore, there's DNA evidence, there's blood spatter evidence. Those things are consistently presented. Oftentimes I wonder why it is presented or whether it's really relevant to the case. And I've also found that oftentimes the prosecutor may not really understand it, nor does the defense lawyer. There are not motions filed, there are not objections made. Sometimes the terminology that is used in the courtroom really doesn't match what the report says. Sometimes you will find that the people at the lab make mistakes, as has been proffered today. I've brought with me today a case that comes out of the Court of Common Pleas of Butler County. It is one of the most interesting cases you'll ever read, and it kind of couples everything that was said here this afternoon into one opinion. It is the case of Commonwealth of Pennsylvania versus Benjamin Breuer. It is a prosecution in Butler County, 2010, 1385, and it is an opinion by a friend of mine, Judge Tim McCune. I'm going to go through the facts because those facts will say something to you about everything that was said here today that often happens in courtrooms. But before I do that, I think one of the major problems that courts confront in cases is this. The prosecution has at its disposal a laboratory, Greensburg Crime Lab. If you have a privately retained attorney, oftentimes the client is really scraping to get enough money to pay the attorney and doesn't have sufficient funds to get all the expertise on the other side. If it's a public defender or a conflicts counsel who's appointed, sometimes the courts are discretionary in how much they will allocate on the other side. So as a result, oftentimes what you have is the prosecution presenting DNA evidence without any counter evidence. Even though that's the case, that doesn't mean that the defense lawyer can't do something in connection with that. Let me go through the facts of the Breuer case with you because it's fascinating. And Dr. Perlin was actually involved in this case. The defendant was charged with 2 counts of rape, 1 count of sexual assault, and a lot of other related charges. He was charged by a local police department. The local police department took the underage victim, who was 16, to a hospital. There was a rape kit done. And furthermore, they allowed the hospital, not the officer, to package the items. First thing the hospital did was put the bra and panties of the victim in the same bag. That's the way the officer retrieved the items from the hospital, took them to the laboratory in that fashion. And then, I believe, realized at that point the mistake that had been made. They were then separated. They were submitted to the Pennsylvania State Police Crime Lab in Greensburg. At that time, they were given to a serologist who was fairly new. The serologist did an analysis under an ultraviolet light. She spotted areas that she believed to be DNA, and she found 1 area of sperm. However, that was it was found to be 1 sperm head. The statistic would show if someone actually ejaculated, you would find many, many, many more sperm heads than that. She cut a part of the underwear and sent them over. And also, this serologist testified at the preliminary hearing. And at the preliminary hearing, so you know, the serologist testified that she agreed on cross-examination that the one sperm head would not necessarily be indicative of, and by the way, I apologize, this was a sperm head in the victim's underwear. And she admitted that that would not necessarily be consistent with what ordinarily happens in an ejaculation type situation. But she did say it could be pre-ejaculation or something like that. Should also note they found no DNA sperm in the victim's vagina, in her mouth, or in the anal part of her body. The part of the victim's underwear were then sent over to a forensic scientist in the Pennsylvania State Police Crime Lab, and he did a YSTR analysis on it and extracted a non-sperm area from the DNA. The sperm area did not match the defendant. However, when the non-sperm was extracted, he made a determination that the male individuals who lived in this house, and I'm going to add some more facts here now, there was the defendant and 4 other males, including his father, that lived in the house, that they could not be excluded as the contributors of the non-sperm DNA in the underwear. And he testified, however, that that was his basis for connecting the defendant to the underwear. Now, furthermore, as you go on in connection with this, all of these individuals lived in the house, and it was established through testimony that the young girl was at the house that day and had changed her clothes within the house and had her underwear and bra exposed to what was ever in the house. Dr. Perlin was called to testify in connection with this case. He testified that what was there was indicative of nothing in connection with this case and could have been transferred to the underwear or could have come from just sitting in the house or anything in connection with the house. Now, nevertheless, they pursued the prosecution of this defendant, asserting forcible compulsion in connection with the rape and sexual assault. The defense lawyer was astute enough to file motions in limine and a motion to suppress the testimony of the serologist and the forensic scientist. Now, is this up on the board? This is the order the Judge McCune issued in connection with this case. He found not only wasn't the DNA relevant, but also the testimony did not in any way connect the defendant to the crime. As a result, he suppressed the testimony of the serologist and the DNA specialist, or what they call a forensic scientist at the laboratory. This is the type of thing that can be done maybe in a minimal expense type of way without the necessity of spending thousands and maybe much more than that of dollars in connection with an expert. I throw this out as an example, and I strongly ask you to get a hold of this opinion because it captures much of what is being said here today in connection with this type of situation. In a case that I presided over recently, and I can't name names because some of these cases are still pending, but this is the type of thing that does happen. There was a homicide that was a cold case homicide. And again, I think the state police has received a grant to go back and analyze a lot of these, and they go back under an ultraviolet light, and as they get more evidence, they compare it. The facts were essentially that the victim was a drug addict. The victim had become a prostitute in connection with her activities because that was the way that she was able to get drugs essential to feed her addiction. She was bludgeoned on the head with a rock and found in a shed behind an old steel mill. Now, the defendant who was charged, his DNA was found in her vaginal cavity. However, in connection with this case, there was also DNA of another identified individual found in the crotch of the woman's pants that were pulled down below her knees. There was also a mixture of DNA found under her fingernails. And the report said that the defendant could not be excluded from that DNA mixture. Now, it was a privately retained attorney, and he did an admirable job. But there was nothing actually brought out about the DNA in the crotch of the jeans in significance in connection with this case. More importantly, from the time that the words came out of the forensic scientist's mouth that the defendant's DNA could not be excluded from underneath the fingernail of the victim, from that point forward, the prosecutor, without objection, said and argued the defendant's DNA was under the victim's fingernail. What more do you need, ladies and gentlemen? There was not one objection to that type of argument and the way it was referenced in the case. Now, I don't think it was malicious. In fact, I don't in any way doubt that it was not malicious. Rather, I think what happens, and I'm going to harken back to what I was talking about people not really understanding process or what methodology in connection with what happens in a laboratory. I think that their knowledge of what happens is so superficial on both sides. And I'm not being critical of the prosecution because in many cases I don't think the prosecution's doing anything malicious. Rather, it's a situation where oftentimes people at the laboratory are left in control of matters. And they do certain things. The police officers, the assistant district attorneys, they accept it. The defense lawyers accept it. There's no challenge to it. When I worked with Dr. Perlin, in the case that I worked with him on, I learned something that just fascinated me. And it's really a difference in methodology that exists today in our court systems, in our laboratories. Dr. Perlin's computer analysis, Trulé, analyzes DNA from the very ground floor up. He can determine if there is any segment of DNA in a case. It starts from the bottom floor. What he educated me on, and what I questioned the laboratory people on during the trial in which he assisted me, was the following, and these are the answers that I got. Isn't it a fact that you create an artificial threshold? Yes, that's true. In a laboratory, the laboratory sets its own threshold in connection with DNA analysis. If the DNA findings fall below that threshold, it's never examined. It's because the laboratory believes that DNA may not be sufficient for analysis. Okay? I'm not saying they're right or wrong. I'm just saying that's the comparison and the contrast in the analysis that occurs today. More importantly, Dr. Perlin's system has been peer-reviewed, meaning that he's had people review his system, and they've written articles approving his system as per peer review. However, in connection with the State Police Crime Lab, there is not a peer review. They do certify their machines. They keep them up to date. Everything that is done with those machines is certified. However, the methodology they use has never been peer reviewed, such as Dr. Perlin's system. Now, it's just a difference in approach. I'm not here advocating for one or the other. But if I had not talked to Dr. Perlin, I never would have known to ask those questions. And I bet you, how many people in this room know that? Knew that prior to today? I mean, it's something that is never asked. It's something that's never pursued. Those are the kind of things that exist in our world today, and DNA is developing ever so quickly. In the case that I work with Dr. Perlin on, the serologist was sent certain materials, analyzed them under a black light, found 125 areas of positive for DNA, chose only to submit the 25 that contained sperm to the forensic scientist for testing. The serologist made a determination that this was a sex crime and the other 100 areas were not relevant to the prosecution. I asked if she had in any way conferred with the police in connection with that. No, I made that determination on my own. Now, at that time, she only had, I think, 2 or 3 years as a serologist. These are the types of things that are happening. I know that this is a difficult area. I know it's going to continue to develop. And oftentimes, having tried cases for 30 years, it's very difficult as a judge to sit, bite your tongue, and watch. But that's my job. I'm no longer playing third base. I'm an umpire. Okay? I'm only giving lawyers the benefit of my experience and thoughts on both sides. This area is developing. People need, if they're going to be involved in it, and it's going to be used more and more, because quite frankly, when I hear blood spatter experts and I hear them, I mean, that's a very, I don't know how to describe it, but it's a very unique area. And after you hear some of these people from a laboratory testify on a number of occasions, either between your practice and as a judge, it's almost like robotic. They're trained with answers, those types of things. But I really encourage people on both sides to visit the lab, to learn more about the methodology that's involved, because it's only in that way that justice can be accomplished, that we can get to truth. In working with Dr. Perlin, he told me from the very get-go, look, I'm only going to help you if I believe in your case. I'm going to give you the good, the bad, and the ugly. Okay? And that's all anybody can ask for. That's all our court system can ask for. But in light of this book, in light of this study, this is something that's still developing. We're only 8 years removed from the study of the National Academy of Sciences. And we're on the verge of, as everyone said here, what we're talking about today is going to be out of date in 5 more years. But I would like, as a judge, nothing more than to see both sides fully prepared for these types of situations, not only in presenting the evidence and defending it, but understanding it, because I think that's what's lacking today. So thank you very much for your time.
Thank you very much, Judge Roth. That was excellent.